Imagine this, okay? You've just inherited your aunt's home. It's this cherished family place, full of memories. But then you hear that word, that legal term that instantly makes your stomach clench a bit. Probate.
Mm-hmm.
It just sounds complicated, maybe expensive, and frankly, like a huge headache you absolutely don't need right now.
Yeah, it definitely has that reputation.
So today, we're taking a deep dive into probate in real estate. And we're going to look specifically through the lens of Pennsylvania law.
Right, because the rules can really differ state by state.
Our mission here is basically to be your shortcut. We want to slice through all that dense legal jargon, pull out the most important, maybe even surprising insights for you.
Exactly.
By the end of this, you should not only understand what to expect if you ever find yourself navigating a probate sale, but hopefully feel a lot more confident about the whole thing.
That's the goal. Clarity and confidence.
Okay, so let's unpack this common misconception right off the bat. When you hear probate sale, does that mean something shady, like illegal or wrong? Is the house somehow tainted because it's going through probate?
Absolutely not. That's a really important point to make clear.
Yeah.
Probate is a totally normal, very common legal procedure. It's just the system we have.
Okay. So when someone passes away, everything they owned, right? Their money, investments, and yes, their real estate, all of that becomes part of what's called their estate.
Exactly.
Yeah.
And probate, well, in essence, it's the legal process that steps in to figure out how those assets are going to be sold or distributed among the heirs.
Okay.
Probate sales often come up precisely because a home has been inherited from someone who passed away, especially if maybe the will is a bit imprecise or perhaps, and this happens a lot, the person didn't leave a will behind at all.
Oh, okay.
That's when the court has to get involved, just to oversee things and make sure it's done correctly.
So like a referee.
Kinda, yeah. And it's important to reassure you, the listener. While the legal process itself, yeah, it can take a bit longer, these properties absolutely still hold value. These proceedings happen every single day for very good reasons, and they ultimately benefit both the family and often the person who eventually buys the home.
Okay, that's good to know. So if you're looking at a property, maybe you're a buyer or maybe you're the heir, how do you know if the sale actually involves probate? What are the telltale signs?
That's a great question because it's often not immediately obvious just from, say, a listing.
Right.
The core insight here is if the original property owner has passed away and the property is being sold by one or more of the heirs,
Okay.
and especially if a realtor is involved who mentions anything about needing court approval for the sale.
Ah, okay. Court approval is a key word.
Definitely. That's a big flag.
Yeah.
You're almost certainly looking at a probate sale then. It's not just a private family matter once real estate and courts get involved.
Gotcha.
You'll also typically see that the heirs, they only receive the official title to the property through the probate process. And the sale itself can only finalize, close once that title is formally transferred to them as the new lawful owners.
Okay, so it's a formal transfer of ownership supervised by the court.
Precisely.
So let's say the owner passed away and the heirs want to sell. That flags it for probate. But that leads to a really critical question. Does a homeowner's death always mean probate? Like, is it automatic?
No, absolutely not always the case. That's another common misconception.
Oh, interesting.
Yeah, in fact, many people proactively plan ahead, specifically to avoid probate altogether with their real property.
How do they do that?
Well, the most common way is by working with a lawyer, usually an estate planning attorney, to set up something called a revocable living trust, or sometimes an irrevocable trust.
Okay, a trust.
Right. Think of it like this. Instead of the property being owned directly by the individual, it's owned by the trust. So when the individual passes away, the property technically doesn't go through their personal estate for probate.
Ah, because the trust owns it.
Exactly.
Huh.
It's already managed by the terms of the trust, which then dictates how it gets distributed to the beneficiaries named in the trust. It's a really effective way to keep real estate out of the court system entirely.
Wow. So trusts are like a bypass around probate.
Pretty much, yeah.
Okay, but here's where it gets really interesting, especially if you're thinking about Pennsylvania specifically. I read that a transfer on death deed is not allowed in PA.
That's absolutely correct.
That seems like a huge difference from some other states. Why is PA law set up that way? What does that mean for residents there?
You're right, it is a significant difference. Many states offer this transfer on death, or TOD deed, as a fairly simple way to name a beneficiary for your real estate, allowing it to bypass probate automatically upon your death.
Right, sounds convenient.
It can be. Pennsylvania, however, requires a more formal process. The specific legislative reasons are, well, complex, but it essentially means you can't just list the beneficiary on your deed here and expect it to automatically transfer outside of probate.
So no easy TOD deed in PA.
Nope. This really emphasizes the importance of proper estate planning in Pennsylvania, either having a clear will or, as we just discussed, using a trust if you want to ensure your property avoids the probate court system.
Okay, that's a really key takeaway for Pennsylvania folks. So we've defined probate. We know kind of what it looks like, touched on how to avoid it. Now, you mentioned probate laws differ by state. Let's zero in on the step-by-step Pennsylvania process itself. Imagine someone, let's call her Jane again, is navigating this with her aunt's will. Where does she start?
Okay, good way to frame it. The journey in PA typically starts when the person named in the will as the executor, maybe that's Jane, maybe it's another family member, takes the original will and files it with the county's Register of Wills.
Register of Wills, got it. And that's usually in the county where the deceased person lived.
That's right, where they resided at the time of death.
Okay. And what if Jane's aunt, like you said, happens often, didn't actually have a will?
Okay, good question. That's where an administrator comes into play instead of an executor.
Administrator.
Yeah. In the absence of a will, often the surviving spouse or an adult child will step up to be the estate's administrator. Sometimes you'll hear the term personal representative used for either an executor or administrator.
Okay, personal representative. So that person takes charge.
Right. This personal representative then submits a formal petition, basically, an application to open a probate case at the local probate court. Now, in Pennsylvania, this court is commonly known as the Orphans Court.
Orphans Court. That's an interesting name.
It is. It has historical roots.
Okay.
But that's the court handling probate matters. Many counties actually provide the necessary forms online now, which is helpful.
Oh, good.
But there is a filing fee, and it can run, into the several $100 range, sometimes more depending on the size and complexity of the estate.
Okay, makes sense. So the petition is filed with the Orphans Court. What happens next to give Jane, or whoever is the representative, the actual legal power to, do stuff?
That's the absolutely crucial next step. The court issues official documents. These are key.
Okay.
If there's no will, the court issues letters of administration to the administrator.
Letters of administration.
Right. If there's a will, the court issues letters testamentary to the executor.
Letters testamentary. Got it.
Think of these letters, whichever type they are, as the court's official stamp of approval. It's the legal document proving the representative has the authority to start acting on behalf of the estate.
So without those letters, they can't really do anything legally.
Pretty much, yeah. They can't access bank accounts, sell assets, pay debts in the estate's name. These letters establish their legal authority. It's fundamental.
Okay. And what about the will itself? If Jane's aunt did have one, how does the court know it's the real deal, that it's legitimate?
Good point. A lot of wills drafted in Pennsylvania nowadays are what's called self-proving.
Self-proof?
Yeah, it means when the will was originally signed, it included sworn statements from the witnesses, all properly notarized. So the court can usually just accept it as valid without needing extra testimony later.
That speeds things up, I bet.
It definitely can. But if the will isn't self-proving for some reason, then the representative will need to track down the original witnesses and get sworn testimony from them to basically confirm to the court, yes, we saw the deceased sign this will, and they seemed competent at the time.
Okay, a bit more legwork if it's not self-proving.
A little bit, yeah. But these initial administrative steps, filing the petition, getting those letters, validating the will, they are absolutely crucial. They lay the legal foundation for everything that follows.
Right, setting the stage. So once the representative has that legal authority, those letters, what's the very first thing they need to do? Can they just, immediately put the house up for sale?
Not quite so fast. With that legal authority comes some really important responsibilities. The first big one is letting everyone know what's happening and starting to figure out the debts.
Okay, communication and debts.
Exactly. The representative is legally required to notify the public, any known creditors, the beneficiaries named in the will, and any legal heirs that the probate process has started.
How do they notify the public? Put an ad somewhere?
Usually, yes. You might have even seen these notices, small print ads in local newspapers officially announcing the opening of an estate.
Okay, I think I have seen those.
And here's a key point specifically about selling property, like the house. During a probate sale, the deceased person's assets, the house, maybe other things are sold, but before the heirs get their share, any outstanding debts or taxes owed by the deceased must be paid first using the proceeds from those sales.
Okay, so creditors and taxes get paid before the beneficiaries. Makes sense.
The estate has to be settled financially first.
This brings up a common question, and maybe a surprising one for some listeners. Can an executor, let's say Jane was named executor in the will, can she sell the probate property, the house, without getting formal consent from all the other beneficiaries in Pennsylvania? It sounds like a lot of power.
It's an excellent question, and it does sound like a lot of power. The answer, according to Pennsylvania estate lawyers, is generally yes. The estate representative can sell probate properties, including real estate, without getting formal written consent from every single beneficiary beforehand.
Wow, really?
Yes. But, and this is a huge, but what's fascinating here is the concept of fiduciary duty.
Fiduciary duty. Okay, what's that?
It means that even though they don't need explicit consent for every action, the representative is legally required to follow the terms of the will, if there is one, and crucially, act in the absolute best interest of the beneficiaries. They can't just sell the house for a low price to a friend, for example.
Okay, so there's a legal obligation to do right by the heirs.
A very strong one. It's the cornerstone of their role.
That's quite a responsibility. So what if the beneficiaries do have concerns? Maybe they think the house is being sold too cheap or too quickly. What kind of checks and balances are actually in place to make sure that fiduciary duty is upheld?
That's where transparency and court oversight come in. First, beneficiaries absolutely must be notified about major actions, like the sale of real estate. They have the right to get information and question every action the representative takes.
So they're kept in the loop.
They should be, yes. And if they have serious concerns, like they believe the representative isn't acting properly or in their best interest, they can actually petition the probate court, the orphans court, to review the real estate sale or other actions.
Ah, so they can ask the court to step in?
Yes. The court doesn't usually need to approve every single transaction before it happens, but the representative is required to submit regular status updates or accountings to the probate court, showing what they've done with the estate assets.
Okay, so there's this ongoing reporting and the potential for court review if needed. That makes sense.
Exactly.
All right, beyond the legal steps and duties, what about the money side? Specifically taxes in Pennsylvania. What do people inheriting property need to know?
Right, taxes are always a big question. The main one to be aware of in Pennsylvania is the Pennsylvania inheritance tax.
Inheritance tax, okay.
This tax applies to basically anyone who inherits property or assets from a deceased individual, unless they are the surviving spouse or a charity. Spouses and charities are exempt.
Okay, so children, siblings, friends, they might owe this tax?
Correct. The rate varies depending on the relationship to the deceased. For example, direct descendants like children pay a lower rate than siblings, who pay a lower rate than unrelated individuals.
Interesting. What does it do?
It's officially due 9 months after the date of death. But there's a little incentive.
Yeah.
If the estate pays the estimated inheritance tax within 3 months of the death, they get a 5% discount on the tax owed.
Oh, discount for paying early. Good tip.
Yes. Now, on the flip side, some good news. The state of Pennsylvania does not have a separate state estate tax. Some states do, but PA doesn't.
Okay, no state estate tax. What about federal?
Federal estate tax is something most people don't need to worry about. It only applies to extremely large estates. For deaths in 2024, the threshold is over $13.61 million per person.
Wow, okay. 13 million.
Yeah. So thankfully, more than 99.9% of estates in the U.S. do not owe any federal estate tax at all.
That's very reassuring for most families. So inheritance tax is the main one in PA.
For most beneficiaries, yes.
Okay. So after all these administrative steps are done, the notifications, the debts paid, the taxes sorted out, what's the final act in this probate play?
Well, the final act is the payoff, so to speak. Once all the legal hoops are jumped through, all the bills and taxes have been settled, the representative is finally ready to distribute the remaining assets, give the heirs their rightful share of the estate according to the will or state law if there's no will.
Ah, the distribution. That's what everyone's waiting for, I imagine.
That's the light at the end of the probate tunnel, yes.
Okay, so let's shift focus back to the inherited home itself. For someone like Jane, inheriting her aunt's house, it really can feel like either, a difficult nuisance or this beautiful gift.
It can be both, honestly.
Yeah. Regardless of how you view it initially, you essentially have three main options for what to do with the house.
Yeah.
You can move in yourself, you could decide to rent it out, or you could sell it.
Those are the main paths, yeah. Depends entirely on the individual's situation, finances, and connection to the property.
Selling it often sounds really enticing, especially because of the potential income. But before someone jumps into selling an inherited property, especially in PA, there are some really important questions they need to ask themselves first.
Absolutely. Due diligence is key.
First off, back to our main topic. Does the property sale need to go through probate? And as we've discussed, if the property wasn't already put into a trust, or if your name wasn't somehow already legally attached to the deed before the death.
Which, remember, that simple transfer on death deed isn't an option in Pennsylvania.
Right. Then yes, it will likely need to go through the probate process we've been talking about.
High probability, yes.
Second big question,
Well,
does the property have an existing mortgage?
very important consideration.
If it does, how's that going to be handled? You know, could the heir maybe take over the deceased's mortgage payments, maybe refinance for a potentially better rate?
Those are possibilities, yeah,
Mhm.
depending on the lender and the heir's financial situation.
Or, of course, if the home is sold through the probate sale, the proceeds from the sale can be used to pay off that mortgage entirely. Usually that needs court approval as part of settling the estate's debts.
Correct. Paying off debts is a primary use of estate assets during probate.
Third question, and this can be a big one, what will it actually cost to make the house sellable in today's local real estate market?
The condition question.
Yeah, because many inherited homes, let's be honest, are older. They might need some pretty expensive updates. Maybe a leaking roof, foundation issues, even just serious landscape work to improve curb appeal. These costs can really strain your personal finances if significant repairs are needed before listing it.
Definitely. You need to weigh the potential sale price against the cost and hassle of repairs.
And that leads to the fourth question. Does the current real estate market even seem favorable for selling?
Market timing, always tricky.
Right. It's always wise to do some research on the local market. Look at comparable homes what have similar houses in the neighborhood sold for recently. You can even use tools like the sold filter on websites like Zillow to get a real sense of values in that specific area.
Good practical advice. Understanding the market is crucial for setting expectations.
So considering all that, what's the typical timeline? If someone decides to sell a house that's in probate in Pennsylvania, how long does that usually take?
Well, the typical timeline for selling a house in probate in Pennsylvania, it really can vary quite a bit. But generally speaking, you're likely looking at several months, potentially even longer. It depends heavily on the local court schedules, how complex the overall estate is, and whether any unexpected issues pop up, like problems with the property title.
So patience is needed.
Patience is definitely needed. The key insight here, though, is that working with local professionals who understand the process specifically, a good probate attorney and an experienced real estate agent familiar with probate sales, can absolutely help streamline things and potentially speed up that timeline.
Okay, having the right team is important. Now, here's another common concern, especially with older inherited homes. Do I have to make repairs before selling an inherited property in Pennsylvania? Does the heir have to sink a bunch of personal money into fixing it up before putting it on the market?
The fix-it-up dilemma. The good news here is no, you absolutely do not have to make repairs.
Oh, okay.
Many sellers, especially those dealing with probate and potentially limited funds or time, choose to work with home buying companies or investors who specialize in purchasing homes as is.
As is, meaning
Meaning, they buy the house in its current condition. No repairs needed from the seller, often no cleanup required, and usually no out-of-pocket expenses for the seller related to fixing the property.
wow. That sounds much simpler.
It can be a significantly faster and often more affordable route, especially if the house needs major work or the heirs just want a quicker, cleaner sale without the hassle of managing renovations.
That's a really valuable option for people to know about. So, okay, taking all this in, what does it all mean for someone, like our hypothetical Jane, who's trying to navigate this whole process? It really seems to underscore the critical importance of getting the right professional guidance. This isn't really a DIY project, is it?
Generally, no. Trying to navigate probate, especially with real estate involved, without professional help, can be really challenging and potentially lead to costly mistakes or delays.
Right.
There are a couple of key professionals who can provide truly invaluable assistance. First and foremost, a probate attorney.
The lawyer.
Yes. A local probate attorney is your guide through the entire probate sales process. They'll help with preparing and filing court documents, advise on legal requirements, and crucially, assist with the final accounting.
The final accounting. What's that?
That's a detailed report submitted usually towards the end of the process. It lists all the estate's contents, shows how the assets were managed, what was sold, what debts were paid, and outlines the proposed strategy for distributing the remaining assets to the beneficiaries.
Okay, like a final balance sheet for the estate.
Pretty much, yeah.
Yeah.
The attorney also handles communication with the probate court. Second key professional. A real estate agent who has specific expertise in probate real estate sales.
Not just any agent.
Preferably not. An agent experienced with probate understands the court confirmation process, the specific disclosures required, and the potentially longer timelines involved. They know the nuances.
That makes sense.
Now, related to that final accounting, it's customary in PA for beneficiaries to sign something called a family settlement agreement. This basically confirms they've reviewed the accounting and approve of the proposed distribution plan. It helps wrap things up smoothly.
Okay, everyone agrees.
Ideally, yes. And one more point. If a representative is worried about potential future claims from unknown creditors popping up later, they might choose to formally submit that accounting to the orphans court for approval. If the court approves it, it can legally cut off the ability of third parties to make claims against the estate assets later on.
Ah, like extra legal protection.
Exactly. Just be aware that probate courts often require these accountings to be submitted on their own specific forms. The attorney handles that.
Got it. So if you've just inherited a house in Pennsylvania and you're feeling overwhelmed, who should you talk to first? What's step one?
Good practical question.
My advice, based on everything we've discussed, would be start by consulting with a local probate attorney. Get a clear understanding of your specific situation and your legal obligations as an heir or potential representative.
Absolutely. Step one is legal counsel.
Then, if you are considering selling the property, especially if you're leaning towards that simpler asses route, reach out to a trusted, reputable local home buyer or real estate investor. They can walk you through your options, often provide a cash offer quickly, and usually with absolutely no pressure.
That's a good sequence. Understand the legalities, then explore the selling options that fit your needs.
And just to reiterate a key point, it is often possible to sell a house during the probate process in Pennsylvania. You don't always have to wait until the very end.
That's true, although the sale will absolutely be subject to the court's rules and timelines. Title typically only transfers formally to the heirs after probate is finalized, or near the end.
Right. But cash buyers, those ass buyers we mentioned, are often experienced with this and can work with sellers during probate. They can enter into a contract, maybe contingent on court approval, and then close the sale quickly once that approval is granted.
Yes, they understand the process and can often accommodate the probate timeline.
So there you have it. It seems like navigating the complexities of probate, especially when real estate is involved like this, can certainly feel daunting at first, no doubt about it.
It really can.
But hopefully, as we've unpacked today, with the right professional guidance and a clear understanding of the actual process, particularly the specifics in Pennsylvania, it absolutely can be streamlined and made much less stressful than people often fear.
I agree. Knowledge really is power in this situation. And perhaps here's a final thought for you, the listener, to consider. Building on that, how might understanding these specific, sometimes granular details of state-level legal processes, things like Pennsylvania's unique orphans court, or the nuances of its inheritance tax versus no estate tax, how might that change the way you view your own long-term estate planning, or even just your current property ownership decisions, regardless of where you actually live?
That's interesting, thinking beyond just reacting to an inheritance.
Exactly. It kind of raises a broader, important question. How can we best prepare ourselves and our families for the complexities that inevitably arise from, well, the inevitable? How do we ensure clarity and ease for those who come after us? Something to reflect on.